Hi friends, Kaushik Ranchod, immigration attorney, been practicing over 20 years, here to share another success story. We're going to be talking about some specific hardships that could apply to you. Could being a member of the LGBTQ community make a difference in your case? What about the fact if you're only here for a very short period of time or were here at a young age for your J1 program? Finally, what kinds of mental health hardship could help you qualify? We're going to be discussing all of this in our case study, so stay tuned till the very end because these forms of hardship may apply to you and could be helpful in your case. All right, let's get started. Let's get to it. First of all, we're going to give you the processing time so you can get familiar with the latest processing times. We filed with USCIS and Department of State on June 23rd, 2022. On July 7th, 2022, Department of State processed the case and USCIS issued a RFE on May 23rd, 2023. Anytime an RFE is issued, that is going to slow down the processing time. So you have to take into account that it does take time to respond to the RFE. Generally, you're given 90 days. If it's our firm, we want to prepare a very thorough response to the request for evidence because depending upon how you reply to the request for evidence is going to determine if you have an approval or denial. And you'll see that in this processing, overall processing times for this case took a little over 2 years. Part of the reason here was because of this request for evidence. Department of State processed the I-613 from USCIS on December 6, 2023. Department of State issued favorable recommendation July 25th, 2024, and USCIS approved the case on August 1st, 2024. Here our client was an international student. He came to the US at the age of 16 and was in his program for a very short period of time, yet it doesn't matter how long you're in the J1 program. Once you're in the J1 program, you are subject to the 2-year rule. So we discussed the fact that he came here as a student at a very young age. That was part of the underlying equities in this case. And our client was also from Algeria. Now here the qualifying relative was a US citizen, spouse. Want to make sure you know about who the qualifying relatives are so you know who qualifies. So one is a U.S. citizen spouse or lawful permanent resident spouse or U.S. citizen child or lawful permanent resident child. So here there was significant hardship to the U.S. citizen spouse. One of the main hardships here was mental health hardships. The U.S. citizen spouse was suffering from moderate recurrent depression. She also had panic disorders with agoraphobia, post-traumatic stress disorder, and generalized social anxiety. Her doctor had indicated that because of these conditions, it required constant medication management and that this was long-term treatment, long-term care was needed, as well as psychotherapy. So this is very important to give the context of why there is the need for mental hardship. Back it up with evidence such as the physician's recommendation. So if you just said, oh, I have anxiety, I have agoraphobia, that's not going to be something that gets approved most of the time unless you are able to demonstrate that this has actually been a bona fide diagnosis through, for instance, a doctor's letter, evidence of medical records, etc. If she was going to relocate to Algeria, she would have faced some severe challenges, including the unavailability of care that she needed for her mental illness. We also argued that she was financially dependent on her husband and was also emotionally dependent on her husband. Not only that, but combined with the risks of terrorism, religious persecution, and discrimination due to her LGBTQ support, and she also identified herself as bisexual. The American spouse was also practicing Catholic, and she had visible tattoos and visible piercings. And she also had no ties to Algeria, so that's something else that we also discussed as well. So of course, if she was going to go back to Algeria, she would stick out like a sore thumb as an American who does not speak Arabic. And she did not adhere to the cultural norms for women's dress in Algeria, which would have further exposed her to potential persecution and danger. The couple also faced economic hardship. They would have been able to support themselves in Algeria due to the lack of opportunities and the complete language barrier for the American spouse. As I mentioned earlier, the applicant had served only a very short time in the J1 program, 2 days. He'd overstayed, so if he was gonna leave, he'd also be facing a 10-year bar for overstaying, and we brought up that issue as well. The J1 applicant was a hardworking and intelligent individual, fluent in English, Arabic, French, and Spanish, and also was employed in multiple jobs. And we are happy that this waiver made him eligible for a marriage-based green card and employment authorization, allowing the couple to remain together in a stable future. Now, this case was also a more challenging case because anytime you have US government funding, that raises the bar on the difficulty of the case because Department of State is going to ask for sponsor reviews, and the sponsor reviews are going to weigh heavily in the determination of whether your case is approved or not. So you have USCIS that has to approve a case and Department of State. So we're very grateful that we were able to take on this case and get it approved. And I hope this video served you. Make sure you subscribe to get the notifications. And if you're watching this video, you're bettering yourself. By bettering yourself, you're bettering your family. And by bettering your family, you're bettering the world. Thank you. Bye for now.